Mainit na balita.
You conclude that Congress is given the discretion to determine the amounts to be appropriated for PhilHealth, correct?
Yes, Your Honor, I believe that that belongs to the discretionary power of Congress.
So to you, it is still Congress that determines the amount to be appropriated or whether any amount should be appropriated at all, correct?
That's what Section 37 actually says, Your Honor.
And that is where I have problems with your reasoning. Because your interpretation of these provisions totally destroys the mandates of the sin tax laws and the Universal Health Care Act. If the sin tax laws already determine the source and use of funds to implement the Universal Health Care Act, even if the funds pass through the GAA, their character as earmarked for a special purpose remains intact. And that brings me to my conclusion, that the provisions relied upon by the Solicitor General do not really give Congress any discretion to determine the amounts to be appropriated for PhilHealth. So that we are all on the same page, can we begin with Section 37 of the UHCA that is being flashed on the screen? And can I confirm from your end that said section provides for 6 sources of funding, namely sin tax collections, PAGCOR contributions, PCSO contributions, premium contributions, annual appropriations, and national government subsidies included in the GAA. Agreed?
Agreed, Your Honor.
So let me focus now on the sin taxes as a funding source. There are 4 relevant laws that we are talking about. I will flash them again on the screen. They are Republic Act 9334, Republic Act number 10351, Republic Act 11346, and Republic Act 11467. Do we agree on that?
Yes, Your Honor.
Based on the slide, you can see that Republic Act 9334 was enacted in 2004, 10351 in 2012, 11346 in 2019, and 11467 in 2020. Agreed?
Agreed, Your Honor.
Allow me to show you now the different provisions of those different laws and portions that I have highlighted. So let's begin with RA 9334. Under RA 9334, the sin taxes collected are expressly stated to be, and I quote, for the purpose of meeting and sustaining the goal of universal coverage of the National Health Insurance Program, or the NHIP. Agree?
Yes, Your Honor.
Under RA number 10351, the sin taxes collected, again, I quote, shall be allocated for the universal health care under the National Health Insurance Program. Yes?
Yes, Your Honor.
Now, under RA 11346, as amended by RA 11467, the sin taxes collected shall be, and I quote, allocated and used exclusively by PhilHealth for the implementation of the Universal Health Care Act, as shown here in Section 288A, Paragraph A, and Paragraph B, as well as Paragraph C and Paragraph D. My reading of the 3 laws that we just showed and the highlighted provisions is that a portion of the revenues from excise taxes on alcohol, tobacco, and sugar-sweetened beverages are earmarked exclusively for UHCA. Can we agree on that reading?
Just to be qualified, Your Honor.
How is it qualified?
We have to take a look at Section 37 as well.
All right, I will go there. But for the meantime, Mr. Solicitor General, can we agree that the language of these sin tax laws provide precisely for that? That they shall be used exclusively for UHCA?
Yes, Your Honor, for the implementation of the Universal Healthcare Act.
Yes, okay.
Thank you, Your Honor.
Let me now show you the next slide. This is the 2023 Sin Tax Annual Report. I believe that's prepared by the DOH. And for 2024, on the next slide, the Sin Tax Report. Can we agree, Mr. Solicitor General, that this money generated from the sin tax laws is money collected on a tax?
Yes, Your Honor.
Do we agree that it was levied for a special purpose, namely to fund the Universal Healthcare Act?
Yes, Your Honor.
On the screen is the complete text of Article 6, Section 29(3) of the 1987 Constitution. And the plain language here is this: all money collected on any tax levied for a special purpose shall be treated as a special fund and paid out for such purpose only. I don't think you have any objections to that, right?
It is what it is.
That's
Your Honor.
right. You have, however, taken the position that Article 6, Section 29(3) of the Constitution there on the screen does not apply because of three main reasons. And let me show you what I understand to be your three main reasons. So first will be Section 44, Chapter 5, Book 4 of EO 292, which provides that all income shall accrue to the general fund, and I quote, unless otherwise specifically provided by law. The second ground is Section 10 of the Universal Healthcare Act, which provides that, and I quote, and it is highlighted in the screen, for indirect contributors, premium subsidy shall be gradually adjusted and included annually in the GAA, and that, I quote again, the DOH, in coordination with PhilHealth, may request Congress to appropriate supplemental funding to meet targeted milestones. Correct?
Yes,
That's the
Your Honor.
second ground. The third ground will be Section 37 that you just mentioned, which provides that, it's there on the screen, the amount necessary to implement the provisions of this act shall be included in the GAA and shall be appropriated under the DOH and national government subsidy to PhilHealth. Those are the three main arguments I've discerned from your submissions. Am I correct?
Yes, Your Honor.
All right. So let's go through each one. For EO 292, what is important to you is the phrase, and I quote, unless otherwise provided by law. And according to you, that phrase means that the taxing law must specifically say that the collections should go to a special account. Did I understand your argument correctly?
That is correct, Your Honor.
And your example is the Coconut Investment Fund under Republic Act 6260, particularly Section 8. I think that's flashed also in the screen, which says that the fees levied on the account farmer shall go to a special fund. Correct?
Yes, Your Honor.
At this point, with your indulgence, Solicitor General, can I ask Deputy Treasurer Marino to take the other podium? Deputy Treasurer of the BTR, you just heard what the Solicitor General explained. You agree with that position, correct?
Yes, Your Honor.
And by virtue of Section 8, Republic Act 6260, how did the BTR or the Bureau of Treasury book the COCO levy funds?
Your Honor, we did not book the COCO levy funds prior to 2012. So these COCO levy funds were not part of the books of the Treasury.
Understood. After 2012, how did you book them?
Okay. So first, Your Honor, when we when PCGG remitted the funds to the Treasury upon their successful conversion of the San Miguel shares, it was initially booked as a trust liability. And then upon the finality of the Supreme Court decision and the issuance of the EO back in 2015, 179 and 180, if I remember correctly,
That's correct.
it was booked as a special account in the general fund.
So it's a special account in the general fund.
Yes, because of those issuances, Your Honor.
Is it your position that a special account in the general fund, I'll refer to them as SAG-Fs, okay? Is it your position that the SAG-F will be created only if the law specifically says that the collection should go to a special account?
Yes, Your Honor.
That's following Section 8, 6260. Something like that. Language to that effect.
Yes, Your Honor.
All right. Do you confirm that there are at least 60 SAG-F accounts in the books of the Bureau of Treasury?
At least 60, yes, Your Honor, as reflected in the table B15 of the BESF submitted along with the other budget documents.
All right.
But Your Honor, if with your kind indulgence, the Treasury can submit a list that we are monitoring. There's more than what is reflected there.
Fantastic. So if you can submit that list, that will be great.
Yes, but Your Honor, with one caveat, all of the balances there are subject to ongoing reconciliation.
Understood.
With your indulgence. Thank you.
I'm showing now in the slides 10 SAG-Fs. First, for the fertilizer and pesticide program. Second, for the Mines and Geosciences Bureau. Third, the refund of input VAT. Fourth, are those from the BOQ, National Civil Aviation Security Committee, and HLURB. Another for the Seatbelt Use Fund. Then, for the Games and Amusement Board. Another one for the National Building Permit Collections and Remittances. And finally, for the Insurance Commission. In all of these SAG-Fs, they refer to laws that do not have language directing the creation of a special account. Can you confirm that?
I cannot confirm. I need to take a look at the
I can
laws.
assure you.
Okay.
I read those laws. They do not have that language. So going back to the phrase in EO 292, which says, and I quote, unless otherwise specifically provided by law, isn't it more rational to interpret this phrase taking into consideration the entirety and purpose of the law in treating the funds as a special fund, instead of looking for language that specifically directs the creation of a special fund? And I ask this question in light of the 10 SAG-Fs I just identified, which do not have that language. Would you agree with me that that is a more rational way of understanding the phrase unless otherwise provided by law?
Your Honor, if with your kind indulgence, this provision, the Treasury reads this provision together with another succeeding section, Section 45.
That says what?
With your permission,
Sure.
may I read? Section 45, EO of the same EO, same book 6, Chapter 5, Special Fiduciary and Trust Funds. Receipts shall be recorded as income of special fiduciary or trust funds or funds other than the general fund only when authorized by law.
But those are trust funds. We're
Other-
referring to SAG-Fs.
The income of special fiduciary or trust funds, Your Honor.
So the income goes to a separate account?
There will be a ledger for them, Your Honor, and if it is authorized by law.
Okay. So essentially what you're saying is that additional section you just mentioned now fortifies your argument that there must be a specific language in the law,
Yes, Your Honor.
even if you have 10 SAG-F accounts that do not have that language.
Your Honor, again, we only operate. We only establish the SAG-F ledgers whenever there is a provision in the law. Again, we beg your kind indulgence, but I do not have the specific provisions of the law in order to give you a more concrete answer, Your Honor.
That's okay.
My apologies.
That's okay. I'll go now to the second ground of the OSG, to argue that Article 6, Section 29(3) does not apply, and that is Section 10 of the UHCA. The slide shows the second paragraph of Section 10, and it reads as follows. Provided that for indirect contributors, premium subsidy shall be gradually adjusted and included annually in the GAA, provided further that the fund shall be released to PhilHealth, provided furthermore that the DOH in coordination with PhilHealth may request Congress to appropriate supplemental funding to meet targeted milestones of this act. Mr. Solicitor General, you refer to the first proviso as meaning that the sin tax collections should go to the general fund and should be appropriated only through the GAA. Do I understand your argument correctly?
Yes, Your Honor.
In other words, from this first proviso, you conclude that Congress is given the discretion to determine the amounts to be appropriated for PhilHealth, correct?
Yes, Your Honor. I believe that that belongs to the discretionary power of Congress.
This is also your position when you rely on the last paragraph of Section 37, which says, it's there on the screen, the amount necessary to implement the provisions of this act shall be included in the GAA and shall be appropriated under the DOH and national government subsidy to PhilHealth. That, again, is basis for your position, correct?
Yes, Your Honor, because of three key words. Necessary, shall be included in the GAA, and shall be appropriated by Congress.
So, to summarize, based on EO 292, Section 10 and 37 of the UHCA, it is your position that since an appropriation under the GAA is necessary, there is no special fund to speak of, correct?
Special fund in
As described in Section 29(3).
special fund in a general sense, Your Honor, as a policy guideline for Congress to consider when they determine the amount that they will give to PhilHealth by way of subsidy. It's what we call a soft earmark.
So, to you, it is still Congress that determines the amount to be appropriated or whether any amount should be appropriated at all, correct?
That's what Section 37 actually says, Your Honor.
And that is where I have problems with your reasoning. Because your interpretation of these provisions totally destroys the mandates of the sin tax laws and the Universal Health Care Act to deliver such funds to PhilHealth for the specific purpose of implementing the universal health care. I'm telling you, that's my problem.
I disagree, Your Honor.
Yes, understood. But the basic principle of statutory construction is to harmonize, correct?
Yes, Your Honor.
To make laws consistent with other laws rather than having one considered repealed in favor of the other.
Exactly, Your Honor.
I'm showing you a slide. That is a quotation from the case of Philippine International Trading Corporation versus Commission on Audit. I underscore that portion. Thus, if diverse statutes relate to the same thing, they ought to be taken into consideration in construing any one of them, as it is an established rule of law that all acts in pari materia are to be taken together as if they were one law.
Yes, Your Honor, in pari materia.
So on the basis of this principle, I'm sharing my thoughts with you. I see sections 10 and 37, which you rely on, as provisions merely to trigger or regulate the release of the sin tax collections directly to PhilHealth. That's my take. Is the way I see it, is that the sin tax collections are still exclusively earmarked for the specific purpose of funding the UHCA, only that its release is done through the GAA. precisely because the process must be undertaken to determine the actual amount collected and the proper percentage allocation. And that brings me to my conclusion, that the provisions relied upon by the Solicitor General do not really give Congress any discretion to determine the amounts to be appropriated for PhilHealth. So my question to you is this: would you agree with me that this interpretation of mine harmonizes the provisos of sections 10 and 37 of the UHCA with the undisputed fact that the sin tax collections are meant to be solely used for implementing the UHCA?
Your Honor, I am not in a position to agree or disagree with the legal interpretation, but if I may share the historical experience when it comes to these earmarkings or appropriations.
Now,
Your
wait, hold on. Let me just continue with my questions. All right. I refer you to the second proviso of Section 10. There's a proviso there that says, provided further that the funds shall be released to PhilHealth. The funds collected shall be released to PhilHealth. In other words, if the sin tax laws already determine the source and use of funds to implement the Universal Health Care Act, even if the funds pass through the GAA, their character as earmarked for a special purpose remains intact. Would you agree with my interpretation?
As a declaration of policy and priority, Your Honor, yes, if we interpret earmarks in such a manner.
All right, thank you. And doesn't my interpretation, again, I'm sure I'm very candid, I'm sharing my thoughts. Would you agree that my interpretation as to the allocation of the funds through the GAA, this aligns more with the constitutional requirement under Article 6, Section 29(3), that money collected on any tax levied for a special purpose shall be treated as a special fund and paid out only for such purpose? Don't you agree that my interpretation aligns more with that provision of the Constitution instead of undermining it?
Your Honor, again, my view is influenced by that provision in the EO 292 regarding the
Which is secondary to a constitutional edict, correct?
We understand, Your Honor.
Okay. Given all that we've discussed so far, can I go back to Article 6, Section 29(3)? We're talking plain language here. Can we all agree, Mr. Solicitor General, Mr. Marino, that the plain language of this provision is that if money is raised from levy of taxes for a specific purpose, then it shall be treated as a special fund? That is a directive of the Constitution. Can we agree at least on the plain meaning of that provision?
I guess we can, Your Honor.
Okay.